A year and a half ago, when Alexis first spoke to me about the project, and I was thinking about deciding on a topic that was both legal and current, compensation for the genocide in its various forms immediately sprung to my mind. When you look at the facts which are available, one can see that the economic consequences of the genocide have been extreme. The Armenian genocide has resulted in a near absolute mass expropriation of both the movable and immovable property of the Armenians. Some of the studies have estimated that the stolen assets have amounted to trillions of dollars. Just as an example, on the eve of World War I, in addition to their own private property, the Armenians living in the Ottoman Empire owned about 2,000 churches, 400 monasteries, and almost 2,000 schools. By the end of the war, only 6 churches remained. In 1918, Ambassador Morgenthau, whom we've referred to already this morning, observed that the real purpose of the deportation was robbery and destruction. It really represented a new method of massacre. As a law student in France in 2001, when I started getting acquainted with the Armenian genocide, I wrote a master's paper on the recognition by France of the Armenian genocide. At the time, a law had just been adopted recognizing the Armenian genocide of 1915. My legal analysis at the time was that this law had no legal effect. It was a declaration. It created no rights or obligations. I had ended my paper at the time by noting that while recognition was a step in the right direction in terms of establishing the truth, it was in no way a satisfactory compensation for the heirs of the victims and the Armenian community as a whole. So we wanted to look at what was the situation in 2015. In 2012, there was an important conference on the issue of reparations in Lebanon, where leading experts, and a lot of them are with us today and tomorrow, where they discussed possible avenues, and I think for the first time in a thorough and comprehensive manner, for the pursuit of reparation claims. There was consensus at the time that with the approaching centennial of the genocide, of course, a formal apology and recognition by Turkey was crucial, but that it would no longer be deemed sufficient. And debated at the time were issues such as whether there should be financial compensation for the heirs of the victims, and how and whether expropriated property should be returned or compensated. In our study, Ms. Kim and I attempted to provide a brief overview of the various avenues for obtaining compensation in which the most current developments have occurred and are likely to perhaps materialize into something more concrete in the future. We took as our starting point Resolution 6147 of the UN General Assembly on the basic principles and guidelines on the rights to remedy and reparation for victims of gross violations of IHL of 2005. And this resolution affirms the importance of addressing the question of remedies and reparations for victims of gross violations of human rights in a systematic manner at both the national and the international levels. It refers to various forms of reparation, including restitution, compensation, and satisfaction. Without going into the details of the resolution, it makes clear that the remedies to which victims are entitled should necessarily be envisioned along 2 spectra. First, related to acknowledging the wrongdoing caused, and the second relating to compensating the harm suffered. And I think of interest for us, I would just highlight a few of the measures which fall into the satisfaction category. So the resolution talks about verification of the fact and full disclosure of the truth, official declaration or judicial decision restoring the dignity, the reputation, and the rights of the victims, a public apology, including acknowledgement of the facts and acceptance of responsibility, and inclusion of an accurate account of the violations in training and educational material. So in our study, we started with this satisfaction aspect because chronologically it made the more sense. because the efforts of the Armenian community starting in the 70s focused on recognition as the key goal. And Ms. Kim will discuss this in more detail, going over also the cases before the ECHR where denial have been dealt with. And we chose to end with a focus on the more recent effort cases of actual restitution and compensation for the property lost by the victims. So these have taken the forms of domestic claims by individuals against insurance companies and civil suits against Turkey and Turkish banks. I have very limited time, so I will speak through a few examples, but I just wanted to maybe give a quote again from Ambassador Morgenthau in 1918, who noted the efforts of the Turkish government to collect for itself the benefits of the life insurance policies of deceased Armenians. So in a private meeting he had with Talat Pasha, he said, I wish that you would Talat Pasha said, I wish that you would get the American life insurance companies to send a complete list of their Armenian policy holders. They are practically all dead now and have left no heirs to collect the money. The government is the beneficiary now. Official ministerial memos were sent to all European and American insurance companies, requesting the names of all Armenians insured with them. Morgenthau informed the Ottoman authorities on behalf of the companies that these requests could not be fulfilled. Starting in the 90s, drawing on the experience from Holocaust victims, there were a number of class action cases, and two of them were settled out of courts, reaching settlements. One was for $20 million in the US. I don't think I have time to go into details about the cases using the California Code, maybe just to say that in 2000, California amended its civil procedure code to bestow California courts with jurisdiction over certain claims arising out of these insurance policies held by Armenian genocide victims, and to extend the statute of limitations for such claims until 31st of December 2010. We touched upon the U.S. presidential position with regard to the genocide. And what's interesting with these cases is the insurance companies were challenging the constitutionality of this provision of the California Procedure Code, and argued that California state was preempted by the executive branch policy to prohibit governmental recognition of the phrase Armenian Genocide. According to U.S. law and what is known as the Supremacy Clause, Congress has the power to preempt state law. Insurance is typically a field that Congress has left to be regulated at the state level. However, when the federal government exercises its power over foreign affairs, its actions preempt inconsistent state law. So preemption of state law may therefore materialize through congressional legislation, treaties, and international executive agreement, where the president acts with its powers. In 2003, the U.S. Supreme Court held that executive policy as expressed by international executive agreements was sufficient to preempt state law. So in support of their agreements, the defendants were referring to three specific occasions in which Congress attempts to recognize the Armenian genocide, or to mention the phrase as such, were met by 3 letters by the U.S. president, each expressing the president's concern. These were President Clinton on one occasion in 2000, and on two occasions, President Bush. In 2008, the U.S. District Court in California denied one of the companies. There's been a really back and forth, almost a ping-pong game with these cases, but finally, last year in 2013, the U.S. Supreme Court refused to grant certiorari and decided not to review a ruling. So it's a very lengthy procedural history, sometimes giving hope to the Armenian community and then back for review, and thus far none of these class actions have been successful. but there seems to be a real impetus for these claims, and hopefully the lights shed on the events during this year during the centennial will foster further reflection on adequate forms of redress. Susan mentioned individual property claims in Turkey. I will also just mention that a bill was presented last year before the US Congress that would require the US Secretary of State to provide an annual report to Congress regarding the efforts displayed by the US government to survey and secure the return, protection, and restoration of stolen or otherwise unreturned Christian properties in Turkey. There was a decree in Turkey in 2011 which allowed for non-Muslim community foundations to apply to regain or receive compensation for property confiscated after 1936. So there would need to be actions taken for this to cover property confiscated in 1915, but efforts are certainly underway. And as Susan mentioned, 100 years after the events, it's time for the families of the victims to be adequately compensated for the harm suffered.
As you can see, I'm not Armenian, but as a lawyer working on international criminal law, this is a topic of great personal interest to me. And after Dr. Suni's kind invitation, I might as well apply as well to be Armenian. So I've worked on it. Today I will present a brief summary of recognition efforts, and then touch upon 3 cases from the European Court of Human Rights. It is a very current topic, at least in the human rights world, given that the Grand Chamber of the European Court of Human Rights had a hearing in the Perenchek case in January. Mr. Robertson was there. First, in terms of recognition, general public awareness of the Armenian Genocide started in the 1960s. And then the first reference to it in an international document appears in the 1973 Intermediary Report of the UN Subcommission on Prevention of Discrimination and Protection of Minorities. However, due to the politically charged nature of including and then later deleting the reference to the Armenian Genocide in conjunction with all the debates surrounding the report, the UN Subcommission on Human Rights did not undertake another study until the 1980s. And then in 1985, the subcommission recognized the acts committed against the Armenians as an example of genocide. So moving to Europe for recognition, in 1987, the European Parliament declared that Turkey could not join the European community unless it recognized its responsibility for the genocide. And in Europe, domestic efforts started in France. François Mitterrand, the French president, recognized the Armenian genocide in 1984. And then in 1999, France adopted a law recognizing the acts as genocide. So now, in 2005, the Armenian genocide has been recognized by various parliaments around the world in official reports by the UN and the European Parliament, and many states have also adopted legislative statements, resolutions, or declarations on the Armenian genocide. Turning now to the European Court of Human Rights, it has dealt with the issue of denial of genocide through an analysis of the Article 10 right to freedom of expression pursuant to the European Convention on Human Rights. So I'll briefly touch upon 3 cases. The first 2 concern Turkey, and the last one concerned Switzerland. The first case concerns Hrant Dink, who most of you knew or know, was a very prominent journalist and editor in Istanbul, and he was killed in January of 2007 by a nationalist extremist. And then in 2010, the European Court of Human Rights ruled that Turkey had failed to protect his freedom of expression under Article 10 of the European Convention. The background to this case involves some articles that Dink had published expressing his views on the question of the identity of Turks of Armenian descent. And then his views were interpreted by some as being an insult to the Turkish people. In February of 2004, a nationalist group lodged a criminal complaint against him based on an article of the Turkish Criminal Code, which made it a crime to denigrate Turkish identity. And then in 2005, he was found guilty and sentenced to a 6-month suspended sentence. This was upheld, but following his assassination, the criminal proceedings against him in Turkey were dropped. In 2007 and 2008, members of his family filed applications with the European Court of Human Rights. They alleged that Turkey had violated Article 10, his freedom of expression, among other rights, and in relation to his murder. So in the judgment, the court stressed that Article 10 prohibits restrictions on the freedom of expression when it concerns issues of public interest and where it is part of a political debate. It emphasized that freedom of expression is greater where it involves criticisms of the government, and that governments have an obligation to create an environment where public debate is freely exercised and without fear. The court then noted that Dink was found guilty of denigrating Turkish identity, which indirectly punished him for criticizing Turkey's denial of the view that the events of 1915 amounted to a genocide. So his criminal conviction made him a target of Turkish nationalist extremists, which then led to his killing. So the court found that Turkey had failed to protect his freedom of expression, that his conviction was not necessary in a democratic society, and that his views were expressed in his capacity as a journalist, writing about an issue of public concern. The court also said states have a positive obligation in protecting the freedom of expression. So following the Dink case, the court pronounced another judgment in the case of Taner Aksam in 2011. Aksam is a professor of history and an expert on the Armenian issue, and he had published an editorial criticizing Turkey's prosecution of Dink, and numerous complaints were filed against him under the same article of the Turkish Criminal Code. None of the complaints were carried out as far as prosecutions. However, he then applied to the European Court of Human Rights, alleging that the wording itself of the Turkish Criminal Code caused him stress, apprehension, fear of prosecution, and all of this violated his freedom of expression. The court concluded that there did exist a considerable risk of prosecution faced by persons who express unfavorable opinions on the issue of the Armenian Genocide, and that the threat of prosecution hanging over him was quite real. The court ruled in his favor and found that there had been an interference with his freedom of expression. And then moving to the Perenchek case, which Mr. Robertson also alluded to, in Europe generally, the criminalization of genocide denial is used as a means to prohibit speech that's racist or xenophobic or ethnically intolerant, and genocide denial itself is viewed as a form of illegitimate historical revision because it grossly denies or trivializes a serious international crime. The European Court of Human Rights revisited this topic in the Perenchek case. And to give you some background, Perenchek is a Turkish national, and he attended some conferences in Switzerland in which he publicly denied the Armenian genocide and called it an international lie. The Switzerland-Armenia Association filed a criminal complaint against him, and then he was found guilty of racial discrimination pursuant to an article of the Swiss Criminal Code, which criminalizes racial discrimination, including genocide denial. He appealed. His appeal was dismissed. The appeals court held that the Armenian genocide, like the Holocaust, was a proven historical fact, recognized by the Swiss legislator in December of 2003. He subsequently appealed in Switzerland, and those appeals were also dismissed. So then Perenchek filed an application with the European Court of Human Rights, alleging that his criminal conviction in Switzerland was a violation of his freedom of expression. In the analysis of the majority, the court reiterated that while it was an integral part of the freedom of expression to seek the historical truth about events, it was not the court's role to settle historical issues that formed part of an ongoing debate. It stated that there was little scope under Article 10 for restrictions on political speech or debates of the public interest, and they viewed this as part of that debate. So the majority went on and said whether the events of 1915 could be legally characterized as genocide was a topic of public debate, and that Perenchek had engaged in this debate. So in contrast with the majority, there were two judges that partly dissented, and they actually found that there was no violation of the freedom of expression. And I'll mention their dissent because it's quite interesting for us. These judges stated that this case raised two fundamental legal questions. The first one is the international recognition of the Armenian genocide, and the second question is the criminalization of denial of this genocide. So in terms of recognition, the dissenting judges noted that international organizations, national courts, states, regional governments, including Switzerland, have all recognized the Armenian genocide, and they stated that the Swiss criminal code punishing genocide denial was lawful. They noted Perenchek himself admitted he knew that Switzerland had recognized the Armenian genocide, and he also knew that its denial was punishable under Swiss law. And the dissenting judges found that the criminalization of genocide was both proportionate and necessary, compatible with the freedom of expression, and even required within the European Convention. Genocide denial can be viewed as a form of racial discrimination, intolerance, or hate speech. Although states have a broad margin of appreciation where there is a social consensus regarding the acts of genocide, as Switzerland has acknowledged by passing this legislation. The dissenting judges found that criminalization of genocide denial is on par with the state's obligations under international instruments such as the Genocide Convention. And in applying this to the Armenians, the judges said there's actually an additional imperative to prevent hatred and discrimination against Armenians who were a vulnerable minority in some countries. And I quote, they said, "In a civilized world, there is no public interest in protecting statements which denigrate and humiliate victims of crimes, exculpate or simply identify with criminals, and incite to hatred and discrimination, even if these statements refer to horrendous crimes that occurred 70 years ago, referring to the Holocaust, or even 90 years ago, referring to the Armenian genocide." And the judges concluded their opinion by quoting Raphael Lemkin, who we've mentioned today. And Lemkin was in a rare interview, a television interview in 1949, where he said that the Armenian case was a source of inspiration for him in coining the term genocide. He stated that, quote, "I became interested in genocide because it happened to the Armenians, and afterwards, the Armenians got a very rough deal at the Versailles Conference because their criminals were guilty and they were not punished." And the judges stated that the Armenian genocide was actually the Forgotten Genocide, and that criminalization of genocide denial in the Perenchek case did not breach Article 10. So as I mentioned earlier, the Grand Chamber is having held a hearing in January, so we await the judgment of the Grand Chamber in this case. And in concluding our study and our remarks, it remains an open question whether the satisfaction aspect of this UN General Assembly resolution has been met by all of these efforts, but we hopefully move towards a more universal recognition of the Armenian genocide. Thank you.